family, and welcome back to another episode of Talk the Talk. I'm your host, STRYDE, and joining me today is Inge Labuschagne, and she's the head of legal at STRYDE Consulting. Inge is joining us today to give our viewers some advice and information on retrenchments. Inge is a strong-willed woman. She is confident, headstrong, assertive, and very independent. Sometimes she actually intimidates me too. But I always ask her to please try and put things in layman's terms for people like me that don't understand the law, and many people that are writing into us to actually explain what it is that we do offer from the Women Talk Network. She is a feminist and a trailblazer, working towards the greater good for herself and the people around her. And I think this is one of the reasons, now I know this is one of the reasons that Inge is so passionate about everything that we do. She carries herself with pride, integrity, and dignity, and this is one of the reasons that we wanted to partner with her. So without further ado, let's welcome Inge. And as always, this interview is proudly brought to you by STRYDE Solutions, MFC, and Evo by Nedbank. Hello, Inge.
Hello, Desh.
Thank you so much again for joining us.
Thank you for having me.
You're welcome. So, as I said, we are going to talk about retrenchments. What are the correct legal steps for undertaking or for retrenchments?
Well, Desh, it is important to note that dismissal due to operational requirements is a no-fault dismissal.
Okay.
Section 189 of the Labour Relations Act permits employers to dismiss employees for operational requirements. Now, here I would like to note that nowhere in the Act we hear of the word retrenchment. We talk about dismissal due to operational requirements. These are defined as requirements based on economic, technological, structural, or similar needs of the employer. Like all dismissals, retrenchments must be both procedurally and substantively fair. Section 189 of the LRA requires that all consulting parties to reach consensus on the various matters. The LRA requires that consultation must take place when the employer contemplates retrenchment. That means no decision to dismiss must have been taken. We are only contemplating at this stage. The consultation is a process and not a once-off meeting. This is not a negotiation process, but a consensus-seeking process. Section 189(1) provides that before retrenching, employers must consult any person whom the employer is required to consult in terms of any collective agreement that may be in force. If there is no collective agreement, meetings should be held with all employees that could be affected by the retrenchment. If you have a recognized trade union in your workplace, ensure that they form part of the process from the very beginning. Section 189(2) of the Act states that consulting parties must attempt to reach consensus on the following matters: the possibility of avoiding dismissal or alternatives to avoid dismissal, appropriate measures to minimize the dismissals, measures to change the timing of the dismissals, appropriate measures to mitigate the effect of retrenchment, and the method for selecting the employees to be dismissed, and lastly, severance pay. The LRA provides for disclosure of certain information by the employer on matters relevant to the consultation. Although the matters in respect of which information for the purpose of consultation is required are specified in section 189(3), the list in that section is not a closed one. If considerations other than that which is listed are relevant to the proposed dismissal or the development of alternative proposals, they should be disclosed to the consulting parties. Section 189(3) of the Act requires that the employer to disclose in writing to the employees or the unions all relevant information, including but not limited to the reasons for retrenchment, alternatives to dismissal that they considered, and the reasons why they were rejected, the number of employees likely to be affected, the proposed method of selection, severance pay, and assistance that the employer would be offering for future re-employment. The notice will also serve as an invitation to consult between the parties. The employer must allow the affected employees the opportunity to make representations in relation to the proposed retrenchment, oral or in writing. If the employee makes representation in writing, the employer must also respond in writing. And then lastly, section 1897 states that employers may select employees to be retrenched according to the criteria they have agreed upon by the consulting parties. If no criteria have been agreed upon, the selection must be fair and objective. The LIFO, which is last in, first out principle, is often applied but is not the only principle. Once the consultation process has been concluded, the employer must issue notices to employees who have been selected to be retrenched, and these employees would then be entitled to severance pay.
Inge, thank you so much for trying to put that in layman's terms. I think for me more than anything else, but I think we've got a lot of independent dealers that are part of our network that watch the show, and I think what you've really offered us now with that last question can really help so many people. Thank you. But what are the employees entitled to after retrenchment?
So Desh, the requirements regarding severance pay is set out in section 41 of the Basic Conditions of Employment Act, which states that the employee is entitled to 1 week severance pay for every completed year of service. They are also entitled to any outstanding leave due up to date of dismissal and notice pay, either in terms of the Act or in terms of their contract of service.
Okay, and what is a restraint of trade, and are disciplinary codes effective after a retrenchment? It's a question that I often get as well, because we are in the motoring trade. You have a restraint of trade. Restraint of trade. Some say it is applicable, some say it's not. And I mean, for me, as an example, I'm a motoring journalist. There's nowhere else that I can work. So what happens in a case like that?
Yeah, Desh, we also get this question quite often. And like you said, most people think that once they leave, the restraint isn't applicable anymore.
Okay.
Our courts don't even agree on this principle.
Okay.
But if it is in your contract, you can assume that it might be enforced by a court.
Okay.
A restraint of trade is used to stop the employer's proprietary interest from being accessed by the employer's competitors. The employer's proprietary interest includes, but is not limited to, the employer's trade secrets and confidential information. An enforceable restraint of trade will prevent an erstwhile employee from joining an employer's direct competitor if the employee has acquired confidential information and trade secrets from the employer. By enforcing and relying on a restraint of trade provision, an employer is able to protect their commercial interest. This includes your client list. That would form part of your commercial interest. Our courts consider the following principles in restraint of trade cases. Does the employer have a protectable interest? So you first need to be able to prove that you do have an interest worth protecting. And could the employee potentially prejudice the protectable interest? Is the restraint reasonable? And is the restraint against public policy? Restraints of trade clauses and electing enforcement is not a straightforward matter. The enforceability of a restraint of trade involves making a value judgment to decide whether or not the restraint is enforceable. The employer should also take into consideration the circumstances surrounding the termination of employment. So what that means is a retrenchment does not mean that the restraint of trade is not enforceable anymore. If it is part of your contract of employment, it can be enforced by the employer. You would need to agree upon the waiver of that right by both parties at the end of the process. Employees can accept that if there is a restraint clause in their employment contracts, it can be enforced. Sales executives especially need to be mindful of the fact that the clients that they bring in are the clients of the dealership and not their own. The courts have to strike a balance between the employer's right to protect its unique business interest on the one hand and the employer's right to work and sell his or her skills in a competitive market on the other. An employee who wants to be released from a contract in restraint of trade must be able to persuade the court that his or her right to work outweighs the potential prejudice his ex-employer would suffer. Only then will a court relieve an employee of the need to keep his or her promise. Being retrenched does not automatically mean that the employer waives the restraint of trade.
Okay. Thank you so much, Inge. I think it's very, very valuable advice. We really appreciate you, and we look forward to bringing a lot more of this to our community. Thank you.
Thank you, Dave.
Viewers, we would like to thank you for your continued support and encourage you to like and share our content. Our non-profit companies, the Motoring Woman of the Year Awards, powered by MFC and Evo by Nedbank, and the Talk Studios, sponsored by Sariti Solutions and Evo by Nedbank, are platforms aimed at empowering, uplifting, and celebrating the women of motoring South Africa. We are not just telling stories, we are changing lives. If you are searching for a new or pre-owned vehicle, please visit www.auto.evo.africa. We have a wide range of vehicles on sale for you to choose from, and we only advertise on behalf of reliable and trustworthy MFC accredited dealerships. This car listing portal is user-friendly, and you can also find vehicle reviews, car maintenance tips, and automotive advice, all courtesy of Talk the Talk Studios. Ladies, let your unique awesomeness and positive energy inspire confidence in others. Wherever you go, no matter what, the weather always brings your own sunshine. If you want light to come into your life, you need to stand where it is shining. Success is the sum of small efforts repeated day in and day out. And with that, I would like to remind you that the question should never be who's going to let me. It should always be who's going to stop me.